For the second respondent says the power here in question is executive action, then the binding consideration relevant to whether there is Audi is determined in the matter of Masekela versus the President of the Republic of South Africa. And I beg leave to hand, sorry, these volumes are somewhat, the case is somewhat voluminous, but if I might just hand the case to the court, because this was an instance of a very highly placed official, the head of the intelligence services, who was contesting the question of his removal, not as here simply the issue as to whether there should be an inquiry. And what the court found in that instance is that the power that was exercised by the president was indeed executive action and not administrative action. And the consequence of all of that was then described by the court by the Deputy Chief Justice at paragraph 78 of the judgment, where he explained that the authority conferred must be lawfully, rationally, must be exercised lawfully, rationally, and in a manner consistent with the Constitution. Procedural fairness is not a requirement. The authority of Section 85(2)(e) of the Constitution is conferred in order to provide room for the President to fulfill executive functions and should not be constrained any more than through the principle of legality and rationality. So if it is the case, as is contended, that this is executive action, the contentions made by some of our learned friends to suggest that the Audi principle that is applicable under Parja is of application, is not of application, because the Constitutional Court has said otherwise. And that, of course, has significant consequences, because there is nothing that the courts have ever said that requires, under executive action, that there must be Audi in the sense that that is comprehended for the purposes of administrative action. All that is required is that the process must be rational, nothing more and nothing less. The second proposition is that if it is administrative action, then, so it is said, again, clearly by our learned friend for the President, well, then it is said it's an incident of Parja that there must be Audi. And it was said to be a trite consequence of Parja that there would need to be Audi both in respect of the inquiry question and in respect of the suspension question. But with respect to our learned friends, they have not given proper regard to what the case law says on this score, because we referenced for the court the second, and just to avoid confusion, there are two cases referred to as the Similani case before this court. The first is the one that we referenced in our heads of argument, which more correctly is the Democratic Alliance versus the President of the Republic of South Africa. And perhaps to avoid confusion, if I might call that the DA case, because that concerned the appointment of Mr. Similani as the NDPP and the legality and rationality of the appointment. That deals, as I indicated in my opening address, with the requirement that for the purposes of appointment, it is objective facts that count. For the purposes of rationality review, it has got nothing to do with discretions. The second Similani case, which I also referenced in my opening address, but perhaps I could call the Similani case, and just to recall it, is Similani versus 7-Eleven Corporation, 2003, 3SA 64 SCA. This was a case about administrative action, and so it did directly invoke Parja. What the court does in analyzing the question as to whether there was a requirement for a hearing is it said you have to look at the different stages of what is entailed in a holistic way. And you don't get Audi at every point in a holistic process. So in that case, referencing earlier authorities of Brenko and cases of that kind, it said where you have a two-phase process, and the first phase involves investigation and the second involves some determination that has a consequence, you only get Audi at the second stage, not at the first stage. And nothing about the fact that it's administrative action changes that result. So what the Similani case stands for, which has reference on the facts of this case, is the following: that since the decision as to whether to hold an inquiry is not determinative of any ultimate issues, because it is the inquiry that will determine whether there is a basis for a circumstance in which the removal should take place by the President. The inquiry is the Audi. That is indeed what Parger itself says. You can either have a notice provision or you can have an inquiry. This is the inquiry. So it follows, if one has proper regard to what our appellate courts have had to say about the appreciation of fairness in relation even to administrative action, that one must examine this holistically. And if I could just very briefly, and we'll give the case to the court, but the court said very plainly that to decide whether an administrative action has been taken fairly, it is crucial that the decision-making process be viewed as a whole. The demands of fairness will depend on the context of this decision viewed within the procedural context in which it arises. An essential feature of the context is the empowering statute which creates the discretion as regards both its language and shape. And then it goes on to analyze this to say there is no harm to fairness in any way at an investigative stage, and a person gets the gist of the case that they need to meet at the adjudicative stage, and that too is exactly applicable here. There is no secret as to what the second to the fourth respondents need to deal with at the inquiry. This is all very well known, and they will be given all their rights of Audi at the inquiry, because that is the very purpose of the inquiry. So, as Brenko has said, as the Similani case has said, you don't make a fetish out of process. You don't get fairness on fairness, most especially in the context of the powers that are at stake here, because for the reasons that we've already explained, it's vital that the President discharge his constitutional function so as to intervene promptly and without delay to bring about an inquiry if the objective facts require it. And the reason that we come to court is precisely because the objective facts do require it, and the President has sought to not do his duty, but rather to delay doing his duty through a process that has no grounding in law.
Are you saying that the President acted in bad faith?
No, not at all. Not at all.
So his conduct, well, why are you criticizing his conduct as being unlawful? That's the word that you used.
Yes, the reason that it is unlawful is that there is no requirement to accord this Audi that he is according to the respondents. He has a power to determine whether to put an inquiry into place in circumstances where there is very real urgency about righting the ship of the NPA. And what he has chosen to do is to do something that is not a requirement or entailment of law. So he is saying, I'm going to put off taking a decision because I'm putting in place a process. But if the process isn't required, as we say it isn't as a matter of law, then he is taking a step which is not lawful, is not required, and is avoiding taking a decision which urgently needs to be taken. So it's not a bad faith question at all. It's simply a legality problem that he has created for himself.
What I wanted to check with you, Mr. Ntalda, is your reference to the Masetla case.
Yes.
Where you referred us to paragraph 78.
Yes,
that in the exercise of executive authority, procedural fairness is not a requirement.
Yes.
Now, in paragraph 83, the court seems to countenance procedural fairness.
Yes, Lord.
How do we read that?
Well, as I understand what the court is saying is to say, even if it was a requirement for the exercise of the power, then on the facts it seems that he had ample opportunity. So, my Lord, yes, indeed, my Lord, this paragraph 83 seems to us to be peculiarly relevant to the second limb of the inquiry around suspension. So, if this court should find that even if it's executive action, there is, at least in the context of suspension, some requirement to give some sort of outing. We don't say that that is so because we say they stand on the same footing, but if it was to be so, then we reflect that what happened in paragraph 83 is that Mr. Motshekga was given the opportunity, and so too in this case, because practically speaking, what has happened as a result of the litigation is everything that can be said by these respondents has been said. And so the question is, why has the President not acted, even though we know what they've said? They can't say anything different.
So I should read this affording Mr. Motshekga an audience as only in relation to a suspension part of, because here I read it to be part of, to be leading up to the dismissal, his dismissal.
I think, and that as I understand this passage in the judgment, it's working from a hypothesis. Even if I'm wrong in saying that there's no incident of procedural fairness that is implicated in the exercise of executive competences, then in any event, I don't need to be concerned because he was given every opportunity that he could reasonably. In other words, it says on the facts he's bad and on the law he's bad. And so on either basis he can't get the relief that he's seeking. And we are saying very similar things, that on the law there is no requirement for the representations that are being sought, but even if there were, every reasonable opportunity has been given because this litigation has precipitated whatever it is that the respondents wish to say.
Because the issue of procedural fairness becomes relevant when one reads, I think in almost all the authorities, to say, especially here when we deal with legality and rationality, that it has to be in compliance with the Bill of Rights, isn't it?
It would, although no one, as far as I'm aware, has ever contended, because the sequence of constitutional court decisions that have analysed what is the test in respect of executive action have said it is always a rationality review, and the only aspect of rationality review that is potentially implicated is that there may be some requirement for procedural rationality, but that is highly context specific, and it has never been said that it's constituted by Audi. So, and no one, I think, has yet suggested that, in fact, that though any of those decisions are wrong because they implicate the Bill of Rights in some way, because then the Constitution would be at odds with itself. So I think, with respect, by way of submission, that the Constitutional Court is very clear that if it's executive action, there is, as Justice Yakub described it in the DA case, he said it is the lowest, it's a threshold which is easiest to meet because it's a pure means-ends determination, a pure rationality decision. And that does not implicate the full panoply of procedural rights that are entailed by PAJA, and that's the distinction that we would suggest the case law demonstrates. So if just to capture our central submission on this, it is our submission that if it is executive action, the kinds of expansive procedural claims that are being made both by the President and indeed by the other respondents is not grounded in law. And consequently, the process that has been initiated by the President is not a warranted process. It is simply, as it turns out, dilatory. And it's simply the President not taking a decision when the exigencies of what is at stake here require him to act, and to act promptly. And I'm going to take the court to some of the Constitutional Court decisions which have indicated that constitutional duties of the kind that the President is charged with in this circumstance must be acted upon promptly and with urgency where the circumstances require it. Now, where an institution such as the NPA is on the facts that we have put up, and which for the purposes of urgency one doesn't debate, is a circumstance where the leadership cohort of that agency is incompetent, is lacking in integrity, and has cast a long shadow of doubt over the independence of that institution. That requires the urgent attention of the President to exercise his constitutional competences.
Can they be classified as being irrational?
Yes.
And you submit that they are irrational.
Yes, they are irrational because there is no legal foundation for them. And they are irrational because if they aren't required by law, in circumstances of the kind of urgency which attaches to righting this institution, it is fundamental that one doesn't put in place unnecessary procedures to prolong the situation when what is required on the objective facts is action. And that, we would say, is an incident of irrationality when it comes to the exercise of an executive competence.
There was argument by one of the respondents here that the section of the Act itself does not prescribe the type of inquiry to be undertaken. Why should this one that the President chose to follow be irrational?
The issue is that, as to the type of inquiry should distinguish two sets of circumstances. The one is whether an inquiry is required, which is a question, as the DA case, the first Similani case, has made plain, is you must exercise the power when the objective facts require it. It's not discretionary. So that's the critical dictum that emerges from the DA case, and which is not contested, nor could it be, by any of our learned friends. It's not a question of discretion. It is a requirement of legality that if the facts are there objectively, then the power must be exercised. There is a separate question as to what form should the inquiry take. And that subsection 6 makes plain that the President has got a discretion as to whether it is an elaborate inquiry or whether it is a truncated inquiry. There is flexibility as to what type of inquiry to have. There is no discretion as to the fact that if the facts are there, the inquiry must be initiated. And that is an incident of what the Constitutional Court has found in the DA case, what I'm calling Similani 1. Could I just very briefly pick up on a proposition that was raised by our learned friend for the fourth respondent, who invoked the Labour Relations Act and the position of his client as an employee. It's perfectly clear that the President is not acting as an employer here. The President is acting as through the executive competences that he has to engage in a suspension and inquiry of public office holders. So employment law is not implicated at all in respect of the President's exercise of powers. It might be that the employers, for employment reason, may have to do certain things, but that's not the President's power. The President is not acting as an employer. Could I then just deal with a second theme which was developed by our learned friends?
Just remind me, Mr. Unterhalter, where in your papers do you make the pointed submission or statement that the President here is called upon to make to exercise executive power?
I'm not. I'll ask my learned junior to find the passage. I'm not certain that in the founding affidavit we necessarily characterize it, because that's a question of law as to how properly to characterize the power. But we certainly do, in the heads of argument, go to this question as to what is the right characterization. And I'll just ask my learned friend to find the passage for the assistance of the court. But it's clearly a live issue here because certain different consequences are set to flow. But perhaps I should just make it plain that even if this court should find that it's administrative action, for the reasons that I've given, firstly, we say that you need to look at the composite process. So for the purposes of the order in relation to the inquiry, there is no requirement for Audi. In respect of the suspension, because suspension follows from the inquiry, we say a like treatment is required. But if the court should take a different view and say that some Audi is required for suspension, well, we've made our submissions there that they've been given the opportunity, and that's where that ends. If I could then just deal with this issue around past conduct. Our learned friend for the President in particular wished to emphasize that there can't be urgency in circumstances where all that we are seeking is an inquiry to take place in respect of past conduct, and where is the urgency around the investigation of past harm. Now, we have a number of answers to that proposition. The first of them is just this, that what has happened in respect of the way in which the second to the fourth respondents have discharged their office in the events that we give an account of in our affidavit goes directly to the question is, are they fit to occupy their office? If they are not fit to occupy their office, then plainly they cannot be placed in a position to take actions in the future, pending the inquiry and pending the suspension. In other words, there is a direct relationship between what has happened in the past and why that renders them unfit for their office, which has a direct bearing on can they be allowed to carry on flying the aeroplane in circumstances where they are unfit. If we were dealing with a circumstance of a plain form, as here we say is the case, of incompetence, how could one possibly allow incompetent people to carry on discharging the vital functions that we say are entailed by their leadership positions? It has, what they've done has a direct bearing on whether they can be allowed to stay in place. And that's exactly what the legislation envisages. The whole idea of suspension is that there are certain circumstances, if there are objective facts, where we must suspend because we are looking forward to say we must take this person out of their office, not to punish them for their past wrongs, but to prevent anything happening in the future. So the very power that is granted by Parliament to suspend is clearly a forward-looking consideration. And where the conduct is sufficiently egregious, as we say it is in this case, it clearly has a forward-looking aspect to it that has to be engaged. The second point that we would make is simply to say that, and here, with respect, our learned friend for the second respondent gets our affidavit wrong. We are saying that these positions that are occupied by the second to the fourth respondent are critical positions within the establishment of the NPA. It's because they are such important positions that naturally hugely important decisions are taken by those who occupy that position. And if people are unfit for that position, they can't be allowed to stay in place to exercise their judgments around the daily decisions that they must make at the highest levels of seniority in the NPA.
I understand all that, and I think you going back to what you said in your opening address.
Yes, I don't want to repeat anything.
But I think the crux of what we want to hear is why on an urgent basis?
Yes.
Why do you want this court to substitute its own decision for that of the President on an urgent basis?
Yes.
And please remember what the argument is, that your future harm or damage is speculative. It's based on media reports. On what basis then can one, on an urgent basis, invite the judicial arm of government to do what the executive must do in the agent court on the facts we have.
Can I say that, firstly, as to the question of the future harm which we apprehend, we say there's nothing speculative about it at all, because if persons are unfit for their office, they should, to the degree that we say established, then they must not be allowed to continue to occupy offices where they can exercise important decisions. That is the harm that is done.
I think you've said that before.
Yes.
You're repeating it, yeah.
And that's our answer.
Okay.
It's not a question of saying, I expect that they're going to crash the plane again. The question is, you don't let them back into the cockpit, because that's the harm you perceive, that they have shown themselves to be unfit, and therefore you don't let them back into the position. And if I could just give the court a reference to a Supreme Court of Appeal case which the court might find of assistance, it's Grancy versus Manala, and it's 2013 3 SA 111. It's a decision of the Supreme Court of Appeal that concerned the past misconduct of directors and the question as to whether those directors could continue to serve. And the court there said that there was too high a risk of allowing them to remain as directors of the company, not because you had to show that they were going to repeat the misconduct, but that simply because of their past misconduct, it was impermissible to allow them to continue to occupy the office, because they had shown themselves unfit for that office. So it is highly analogous to the situation that we have here, where you don't have to show that they're going to crash the plane again. You simply say, if you are unfit, you should be out.
Qualified.
You're disqualified.
In the case that you've just referred us to, where there's some inquiries held against those directors, or were they just allegations?
It was as I recall, it was an interim relief application. So the question was, if there was enough evidence to suggest that there was a problem with their fitness to occupy the office of a director, then what was the consequence of that? And the court is astute to say, you don't have to show that they are going to engage in further malfeasance. If they have acted in a fashion which suggests that they are unfit for the office that they occupy, you take them out, you prevent the harm. And if I might just say that the Constitutional Court in the Glenister case again referenced this fact that ex post review is often a very inadequate remedy, where the necessity is to act quickly and decisively to prevent this sort of illegality from perpetuating itself. And that is in the Glenister 2 case, which, just for the purposes of the court, is 2011 3 SA page 347, the Constitutional Court, where at 247 the court recognizes, as the court says, in short, an ex post facto review, rather than insisting on a structure that ab initio prevents interference, has in our view serious and obvious limitations. In some cases, irreparable harm may have been caused, which judicial review and complaints can do little to remedy. So the proposition is just this, that where there is illegality that is shown on a prima facie basis, then the stance is not to say, I am going to insist that you must review in 9 months' time after the President has taken an unspecified amount of time to come to a decision. Rather, one says, let us deal with the matter immediately because of the harm of allowing someone to occupy an office for which they are unfit.
My problem is on this. The objective facts that you are raising here.
Yes.
The President, when he decided that he wants more time,
Yes.
he had not yet seen the facts set out in the application. It was just the media talking about what has happened.
Yes.
So you are saying he should act on the objective facts. Are you referring to what is said in the media?
Not at all. We
Which
wrote
facts are you referring to?
we wrote a letter to the President on the 1st of November.
The facts are set out in the letter.
Yes, and those facts are not, in fact, in contention in these proceedings, because I don't want to go into the factual inquiry. But those facts are objective facts. What Mr. Abrahams did at that interview is a matter of public record. And what we recount about those facts, both in the letter and in our founding affidavit, are not disputed. So when he engages in gratuitous vilification of the Minister of Finance in respect of the rogue unit, which is still under investigation, we have shown in our heads that that is a breach of the ethical code of the prosecutors. And it is, in terms of the case that I referenced, which is the Minister of Justice versus X, an illegality. And perhaps I should just give the court the reference to that case, which did I perhaps give it to the court before? But perhaps if I could just reference it for the court. It is the Minister of Justice versus X, 2015 1 SA 25 SCA. And what the court says in this case is that where there has been, and the relevant paragraph is paragraph 52 of the judgment, a prosecutor exercising this power and wishing to avail himself of immunity under Section 42 is required to show that he or she has acted within the authority conferred by the power in question, which in turn requires him or her to have taken all reasonable precautions to avoid or minimize injury to others. A failure to do so would render his or her conduct unlawful. So if you use a public platform to attack persons who are under investigation but not subject to charge for the purposes of vilification under the ruling in the X case, you act unlawfully, and you certainly act contrary to the ethical codes that are binding upon the prosecutorial services. Now, that's an objective fact. Mr. Abrahams doesn't say that he didn't spend half an hour at the press conference on the 11th of October engaging in the commentary that he did upon Mr. Gordhan and others' involvement in the rogue unit. He said those things, and they're a matter of public record. Well, he's engaged in illegality. He has violated the prosecutorial code as the Jiba case invokes for the purposes of fit and proper. That's objective facts.
Are there other arguments you want to respond to?
Could I and I'll attempt to be brief. On the question of the perception of independence, obviously our case doesn't just rest on perceptions. It rests.
How far does that go towards agency?
Well,
because that's not going to the merits.
Yes, my Lord, we simply raised it because it was raised by others. If the court doesn't wish to hear those matters, I'm entirely content to leave those behind.
Stick to agency, because
yes,
it's an issue that continues to trouble me.
Yes. So if I might then just then deal with what it is that renders all of this urgent. If the court proceeds as we suggest the court should, from the proposition in the 20th Century Fox case, which is to say, accept our case on the merits and accept that a remedy would be due, because that's the approach that one takes. Then the question is, well, what renders all of this urgent now rather than later? And
interesting you say that, because I think Mr. Epstein argued in the opposite direction to say this is on paper, it's what the respondents say that's determinative. So you're saying, if we're just looking at agency, I must just look at what the applicants say and assume they have a good case.
Yes, well that's what the 20th century test is. It says you don't determine urgency on the basis of it's not a Plaskon-Evans question. That's not how urgency is determined. Urgency is determined on the basis of assuming the case for the applicant and the remedy that is sought by them. Make all those assumptions in our favor. Is this matter urgent? And that's the discipline which, regrettably, our learned friend for the second respondent didn't comply with. He started to investigate, as did certain others of our learned friends, whether these are just mere allegations and one needs to then examine what is said at great length in the answering affidavit.
Then let's continue. You are
Yes.
telling us why all this is
Yes.
urgent.
So if it is the case that our case is well-founded on the assumption in 20th century, then two things flow from that. There is egregious conduct that has been performed by high office bearers in the NPA. Egregious conduct, because that's the allegation that we make, and those are the facts that we put up. Those are objective facts. President to act, because that is the constitutional imperative. He's granted these powers in circumstances where leaders of an institution are said to have engaged in these extraordinarily detrimental actions which impugn the integrity of the very institution that they're meant to serve. In those circumstances, the president doesn't have time, as it were, to say, well, I can take weeks and weeks, months and months to address the issue. The requirement is that one acts, and one acts promptly in respect of the discharge of those duties. And there are a number of constitutional cases which speak to the obligation of those vested with these powers to act in that way. And the first of those cases is the Choco case. And if I could just give that to the court. It is in our heads, I think, at page 19 of our heads. It's paragraph 47, where we reference the Chonko case. It says, in respect of the President's own prerogative power, the Constitutional Code held that applicants for pardons were entitled to have their applications considered and decided upon rationally, in good faith, in accordance with the principle of legality and without delay. I'm sorry about the garbling of the pronunciation. Without delay means without delay. So in our submission here, when a critical constitutional institution is imperiled by its leadership for having acted in the manner that they did, the president must act, and he must act without delay.
Says, we demand you do this. He must.
Well, what he must do is he must look at the content of the letter, and he must see, is there something referenced there that meets a standard? And this is the important, I believe, confusion that has prevailed, which is that the president doesn't have to act only when there is a conclusive case. The president acts, as the DA case, the first Similani case, explained, where there is a prima facie basis to think that an inquiry is required. In the case of Similani 1, it was a prima facie basis to think that there was a problem with the appointment of Mr. Similani. So the threshold...
Correct, because I wanted you to remind me. Yes. It was not based largely on misconduct, but it was based on how he was appointed.
It was based on what had happened at the Jinwala Commission, and the fact that he had not demonstrated the conscientiousness that was required of someone to hold the office. And what the Constitutional Court said in that case was that the court was not saying he couldn't ultimately hold the office, but that there had been an irrational failure on the part of the president to appoint him and not take account of what had happened. Now, the test was not, is he conclusively lacking in conscientiousness? The test was simply, is there a prima facie basis to suppose that there is a problem in respect of his conscientiousness? And so the same applies here. When the president gets our letter, which refers to notorious facts that are on the public record, we put before him a prima facie case that an inquiry is required because of the conduct here that has taken place. And it doesn't require him then to have it proven to him that this conduct is so egregious that he must remove them from office. It's only that an inquiry is warranted. And this is where, with respect, there's a measure of confusion.
On the point again, this letter that was sent to the president on the 1st of November,
Yes.
it was also copied to the respondents.
Yes.
And are you still maintaining that it's irrational for the president to say he needs more time and to give the respondents an opportunity to respond.
Yes.
So the president must just look at what is contained in this letter by giving the other parties an opportunity to respond. You submit that that's irrational.
I don't want to repeat my submission, but it is certainly irrational in respect of the inquiry limb of this. Certainly, because that we say is a matter of law. It is more arguable in respect of the suspension question, but as to that, one of the difficulties that we have is because we say there is an urgent need for the president to act. How is it that Parliament can summons Mr. Abrahams to come and give an account of himself in 3 days, but the executive branch of government needs, it seems, 21 days just to elicit whatever responses the respondents may have to give in respect of the suspension issue? We submit that what a proper, rational response is to this situation, which is gravely threatening to a key institution, is to the extent that any representations are required, on that assumption, it should all have been done within days. We put up our letter within a day of the withdrawal of the charges to the president to explain why it was necessary to act. The president, on the other hand, speaks about this process that goes up to the 28th, and then, as his lordship presiding has made plain, doesn't clarify whether that letter pertinently only relates to suspension and not to the inquiry, and gives no end date as to when he's actually going to make a decision.
If the president had issued those letters immediately on the 1st or on the 31st when the decision came out, he would not have delayed, even though he was going the route of getting representation from the...
Well, the difficulty is that all of this is being put as if the president needs my clients to remind him of his constitutional duties. The fact of the matter is that the president has these duties and should be acting on them quite apart from letters sent by my client on the 1st of November. So if we hadn't sent the letters, he would still have been under the obligation.
What I want to understand is, because he asked for an extension of time to get representations, yes. And you also said that it is not legal for him to have done so. So I'm asking, if he had on his own asked for those representation, would it have been proper for you, or would it?
No, it would still not have been proper, because if there's no legal requirement to ask for them, then it's not a rational process to engage in, because you have the power. It is urgently necessary that something is done about what has occurred in the NPA and its leadership corps. You must act. And the best that can be said for the president's conduct in this case is that if there was any need to ask for representations, it should have happened extremely quickly. And as we know, in fact, more than 21 days has gone by. We are sitting here today. We know exactly what the respondent's position is. And so the president has still not acted after all this time. And that, we submit with great respect to the president, is inexcusable given what is at stake in respect of the conduct in question and the harm that it does to the institution if no action is taken timelessly. So that's fundamentally why, both on urgency, there is a clear need to intervene and discharge constitutional duties promptly, and the matter is ripe because on any version, the president is still deferring and not saying that he is going to take a decision at any point in time that he will identify. And so we say the reasonable time has come and gone. And that is why we say, in those circumstances, and this comes to a point made about separation of powers, there is no usurpation by the court of the president's powers. Because if a constitutional office holder, the president, does not discharge his constitutional duties promptly, then that is a justiciable issue, and the courts upholding legality are not usurping any presidential competence.
Clear in that regard is he hasn't said I'm not going to.
That is so, my lord. He hasn't said he's not going to, but the question of timing is highly relevant to the issue as to the duty. The duty...
I think it's relevant to agency. He hasn't said, I'm not going to, but he did something and he's put a date. And everyone sitting here says, well, he's given some people until the 28th, which you say was not required.
Yes.
But the fact is, there's something happening in that office about this issue, isn't it?
Well, my lord,
irrational or not, but something is happening.
Yes, my lord, it wouldn't be good enough, one, if it were irrational, and two, if it has no end date. Because we heard our learned friend for the president. We heard him equivocating as to whether the letter does or doesn't seek representations around the inquiry or not. It's highly ambiguous. But the one thing that we have not heard a word about is that this is not a president who comes to the court and says, rightly or wrongly, I've asked for representation. But the one thing that I am clear about is that this is an urgent matter. And one way or another, I will make a decision.
Isn't it correct to say, at some stage, the president having put certain conduct or certain action in place to say, I'm going to ask for this, which you say is irrational, and has put dates. At some stage in the near future, he's going to say, I'm not holding an inquiry, or I am holding an inquiry.
Well, Lord, I would like to believe that that was true, but there's not a scrap of paper before this court that indicates that that is so.
That he'll say he will or he will not.
No. In other words, he has not made a single commitment.
Yeah.
What is most interesting about the affidavit of the president is there is not a single line that says this matter requires urgent attention, and I undertake that whatever representations come in on the 28th, I will decide by the 5th of December, one way or another.
On all accounts, and speaking for myself, when he issued the letter to the second to the fourth respondents, even if he didn't say so directly, he was saying, I'm considering the demand to hold an inquiry, but make your representations why I shouldn't suspend you. Because why should he go that route if he's not thinking about it?
Lord, I think we must accept that a fair reading of his letter indicates that he is considering the matter. I think that would be a fair reading of the letter.
The question then, why come on an urgent basis to rush him along?
Because, my lord, the two reasons that I've given are firstly because he is engaging a process that is irrational and unnecessary, and that is not consistent with the constitutional obligation to act without delay. And the second point is that he has given no end date for a decision to be rendered, which is also inconsistent with his obligation to discharge his duties without delay. And in those circumstances, a court must, with respect, intervene to insist that legality is upheld, not by way of usurpation, but saying, you have these duties. This is a very extraordinary circumstance where it is necessary that you exercise them promptly. And all that we have on paper before us is whatever you may be thinking about, you have not committed to doing anything by a date that would be compliant with your constitutional duty to render a decision. And in those circumstances, we respectfully submit that the matter is urgent.
Because I think we're whiling time in one place.
Yeah, well, I am obviously responding to the... My Lord, Leonard Jr. points out to me that what the President says at paragraph 6.1.12 at page 165 of the papers is the launching of this urgent application, well knowing that I'm in the process of considering exercising my powers in terms of section 12. Not that I am going to exercise them and giving a date. He just says, here's the process, I'm considering it. And we should therefore be content to wait and say, well, when you finally decide what you're going to do, let us know, and it's not urgent. We say it is. My Lord, I think that fundamentally deals with the the issues on both urgency and ripeness, we do submit for these reasons that the matter is urgent, and the issue has crystallized for the purposes of the powers that we ask the court to exercise. Because if we are right that the power had to be exercised without delay, and there's been a failure to do so, well, that would then found the basis upon which the orders are sought under the rulings in Trencon, which explain where substitution takes place. And substitution doesn't violate the separation of powers. It's an exercise of the court's powers of legality. Would the court bear with me for one moment? I just want to see if there's anything else here. Yes. My Lord, your Lordship did ask for two things. The first was, where in our papers and our heads do we deal with the nature of the power, executive or administrative? If I could just give the court the references. In our heads, we do so at paragraph 73 to 80. We also traverse the matter at paragraphs 39 and 47 of the founding affidavit. 39 and 47. And paragraph 51 of the replying affidavit. And then your Lordship presiding did also want me to just to refer to the case of freedom under law in Jiba and what happened in that.
Where Judge Prinsloo refused urgent relief.
Yes. It's I
don't think it's the Jiba one, unless I'm mistaken.
I think, my Lord, it is the Jiba. It is the Jiba case. It's freedom under law versus Jiba.
Yes.
And there, His Lordship, Mr. Justice Prinsloo, did refuse urgent relief. But if I could simply indicate why that case is entirely distinguishable from the present case, what happened in that case was that the applicants came to court I think on 3 days' notice. There hadn't even been an opportunity for the filing of answering affidavits. And His Lordship, Mr. Justice Prinsloo, though indicating that there was a strong case to answer, said this was in violation of the practice directive, and because the time period was so short.
It dealt with the effects of removing the leadership of the institution.
I think, my Lord, that is in the Dramat case.
No. That's the Dramat case.
Yes, I think as I recall, my Lord, that's in the Dramat case. That was in a rather different circumstance, my Lord, because what happened in that case was that there was a final judgment had been rendered to show that the suspension was unlawful. And then, because that was appealed, the question then arose as to whether it suspended the suspension. And the court said on the facts of that case that it would not be wise on the facts of that case to allow for the suspension of the suspension. But what is clear about the Dramat case, as is clear about this case, is that issue as to what would the consequences of a suspension be is a highly fact-specific inquiry. And all that has been said for the respondents is that they say that these are very important leadership positions. We don't disagree with them. But as the court, the Constitutional Court observed in JASA.
The consideration in the Dramat case as well, that it's a leadership of an important institution.
Yes, but my Lord, there was nothing, it's a fact-specific question.
Yes.
In other words, it's not a question of law as to whether they're irreplaceable or not in the interim.
Yes.
We know that the statute allows for suspension and therefore contemplates circumstances in which it's warranted. The only question is, have they established that their leadership is utterly indispensable to the running of the organization? And that's a merits-based issue, my Lord, which we would go into if we reached the merits. But, my Lord, those in summary are our submissions in reply.
We,
an opportunity to correct something which Mr. Utalta said. It'll just take me 1 minute. That's important, my Lord, because the court may be labouring under a wrong impression. The letter, my Lord, which was written to the President in paragraph 4 says, the matter is urgent and the notice of motion and finding affidavit are attached hereto. That was the application which they brought to set aside the charges as being irrational, which was the charges were then withdrawn and it did not proceed. But this is that application, my Lord, which was given to the President. So the President is asked to consider not only the letter, but this application as well. I thought I should mention that to the court.
thank you, Mr. Epstein. We're going to adjourn to consider our decision, and we'll come back at 4:15.